have the pleasure to introduce Mr. Laurent Ridel, Director General of the Prison Administration in France. And he will explain more to you about the French experience of pretrial detention. The floor is yours, Mr. Ridel.
Merci beaucoup. Je suis d'abord très
Thank you very
heureux.
much. First of all, it's a very great pleasure for me to be with you today, and I believe that our exchange today was going to be very enriching and very interesting. Indeed, I'd like to thank Europris and the European Commission for having given us this opportunity to discuss this subject. I believe that indeed we have a lot to learn from each other. We share the same difficulties, and we have the same types of delinquency in our countries, and we have values and legal frameworks which are very similar. And so I think that it's a very good idea to work together rather than working alone in each of our respective countries. The question of pretrial detention in France is a major issue. France is often, I believe, wrongly presented as the poor student in France, in Europe, in regards to pretrial detention, although I think if we look a little bit further, it's not quite that simple. The problem in France is prison overpopulation and the consequences on the prisoners' dignity and the very difficult working conditions for the personnel and the perverse effects that this can lead to. And the question of pretrial detention is only one element in this very much broader scenario. Pretrial detention currently concerns about 18,000 people and represents 27% of the people who are in detention in our 187 prisons in France. I'd like to point out that this figure, 18,000 individuals in pretrial detention, has not changed in the past 30 years, and the proportion of pretrial detentions compared to the entire prison population has gone from 50% to about 25%. So we have made quite a lot of progress on this subject. However, we do remain at a relatively high level compared to other European countries. And this is all the more regrettable because in the fact that we have this overpopulation, and the people in pretrial detention contribute largely to that overpopulation. The French penitentiary system, in regards to the European situation, first of all, we have 73,000 in-prison prisoners, which is about 105 to 110 prisoners per capita, which is at the higher level of the European statistics. But if we compare with Spain, Germany, or the Netherlands, this rate is increasing considerably, particularly in the past 3 years since the end of lockdown, since our population has increased by 15,000. Then we have 265 individuals on probation, and this is the second highest level in Europe after the British, which means that in France, compared our techniques are strict, but if we add up the number of people in prison and the number of people on probation, we have a very large number of people who are under judicial monitoring. And this means that the development of probation has not led to a decrease in the number of people in judicial monitoring. Second rate, which is also interesting and very important, is the overpopulation in our prisons. Our population rate is at 120%. But the remand centers are where people are being held in pretrial detention and remand detention. That rate is at 140. So we have over 100 establishments which are at higher than 120%, and six establishments which are at 200% population. And those are the very establishments where the people who should be considered innocent and should have better conditions than those who've been sentenced. And that's where the problem is. And the constraints due to this overpopulation have led to a situation we have 2,200 individuals who are actually sleeping on mattresses on the floor and living in very undignified conditions. And the European Court of Human Rights has actually condemned France to remedy this situation. We also have other difficulties due to overpopulation. In addition to the problems related to dignity, there's the fact that the prison sentences become less effective because all the establishment functions find themselves under pressure. We have difficulties with medical treatment. We have trouble preparing meals. We have trouble preparing activities and ensuring that family meeting rooms are fairly distributed in terms of time slots. So the situation is very critical, and this is an endemic problem in France. In the past 50 years, we have been living with this chronic problem of overpopulation. So what are the possible solutions to limit the number of individuals in prisons and improve the situation in French prisons? And particularly in regards to those 27% of our individuals who are in pretrial detention. The first, simplest solution would be to build new prisons. President Macron has ordered 15,000 additional prison cells to be built, but this is not enough. There are also legal issues to be dealt with. In addition, we have to develop various open environment sentences in order to limit pretrial detention. Efforts have been made in the past 30 years, as I mentioned, because the number of individuals in pretrial detention has remained stable, and it's the number of sentenced prisoners who has increased. But there are still a large number of pretrial detention individuals. So those pretrial detentions cover three different types of situations. 10% are people who are in detention for minor delinquency offenses who will be seeing a judge within a week. So they're not in pretrial detention for a very long time. Second category, 70%, about 14,000 individuals are in detention for serious crimes, which are under investigation and sometimes stay in pretrial detention for several years. And the third category, 10%, includes people who have been sentenced, but who have appealed the original ruling. Because in the past 20 years now, in France, you can appeal the rulings as the assize trials. There are other possible judicial solutions, and Madame van der Schat, who's worked quite a lot with in this situation, and she's a prosecutor in France, and she will be able to talk about this more in detail. A lot of, I think she'll confirm that a lot of pretrial detention are due to a lack of means in pretrial investigations. The number of investigative magistrates is not sufficient in France, and our legal procedures in France are very, very complex, undoubtedly too complex, and this sometimes prolongs the investigation periods considerably. I believe it's in Norway that I heard about an investigation that lasted for 1 year for a terrorist who killed several hundreds of people in on an island in vast of Oslo, and within a year that criminal had been judged. Salah Abdesel, the terrorist from the Bataclan, was in pretrial detention for over 6 years. It was a very complex case, but even in more traditional cases, sometimes it takes several years of investigation, and during that investigation period, the people remain in pretrial detention. Another improvement would be to suggest other solutions other than prison for that pretrial investigation period. In the past 10 years, about 10 laws have been voted to try and develop this tool for our magistrates. The most recent of those tools is a very positive one, which is it concerns the house arrest with electronic monitoring, which enables investigating magistrates to place a person under house arrest while at the same time authorizing them to, at some times, leave their house with under certain conditions. They're not allowed to see the victim. They have to respect certain time schedules, etc., and they are monitored. And that program has been underway in the past few years. We currently have 500 electronic bracelets on people in pretrial detention. Some of those are tracking systems and some of them are bracelets. The tracking systems enable us to track the individual's movements. Two recent laws have helped us to develop the use of electronic bracelets, making it mandatory to do a study on the feasibility of using these systems for the accused, and every 4 to 6 months, if a judge decides to prolong the pretrial detention, then a new feasibility study must be used to decide whether an electronic monitoring system would not be better, more suitable than a prison detention. And we hope that this program will continue to develop. We've also developed another program for people accused of domestic violence, and we are very much behind countries like Spain in regards to domestic violence, and there's been a certain number of very serious cases that have been in the news in the past few years, and we have a large number of accused who are in pretrial detention for domestic violence, and very often we consider the best way to keep these accused away from the victims is to put them in prison. And we've come up with a new system which is called pretrial placement. Excuse me, probation placement. Legal monitoring with probation placement. So it's a traditional probation period with traditional constraints, but the person is in an establishment where they are monitored 24 hours a day, but it's not a penitentiary establishment. So this guarantees a certain amount of control, but also a certain distance between the perpetrator and the victim. And very often there is the accused wears an electronic bracelet to make sure that he does not go approach the victim. So these are some of the programs that we've been trying to develop in order to reduce the proportion of individuals in pretrial detention. But once again, I'd like to stress the fact that we, in the past 30 years, have made a lot of efforts to limit the number of people in pretrial detention, and the number of people in detention today is mostly people who have been convicted to short-term sentences rather than people who are in pretrial detention. And I'd like to conclude by announcing a program which has imposed the possibility of for someone who considers that the accused, if the accused believes that they are living in undignified conditions, he can make a special request to a special judge to study the situation. And if the magistrate believes that agrees that the conditions are indeed undignified, then the magistrate can order either a transfer or a release with electronic bracelet. So that's the French situation.
Thank you very much, Mr. Ridel, for a very interesting introduction to the topic and the French situation. We have one straightforward question in the Q&A regarding cells in French prisons. And the question is, do you have multi-person cells in France?
Oui. En France,
the answer is yes. Contrary to other European countries, the individual cells are enshrined in law. It means that all individuals should, of course, except when there's a serious risk of suicide, be in an individual cell. Now, this principle has been enshrined in the law in 1875, and it has been enshrined again in the law in 2000. But due to overpopulation in prisons, this principle, sadly, is never complied with, in particular where there's short sentencing. And it is now the 6th report that's been voted by the French Assembly to finally enforce this principle of individual cells. Out of the 73,000 detainees in France, only 40% benefit from the compliance with that principle, individual cells. Most of them are detained for a long period of time, and so they are able to have a somewhat normal life for 8, 10, 12 years. They get up, they go to work, they can see their family in the parlor, etc. So they benefit from individual cells. However, when the sentence is a short sentence, less than 20% of those detainees benefit from an individual cell. So yes, these are multi-detainee cells, sometimes for 2 inmates, and sadly, sometimes there's a mattress when we have to accommodate more than 2 detainees. And of course, this is not compliant with respect of human dignity. However, we separate those in pretrial detention from the convicts. The law makes it impossible to put in the same cell someone who is in pretrial detention and someone who has been sentenced and convicted.
Thank you for that elaborate answer. I can just follow up with a short question on this. So you mentioned that it's enshrined in law as late as the year 2000 that each prisoner should have an individual cell. And you also mentioned that there's a possibility to make special requests about undignified conditions. Has this been referred to in France as a case in itself of undignified conditions?
Oui, nous
Yes.
avons...
There have been actually several hundred appeals coming from detainees addressed to the judge, as also requests that have been made or appeals that have been lodged with the judge of liberties and freedoms. Most of these appeals have had, as a result, a transfer. That means that the person in detention has been moved to a different prison. So this has a dissuasive effect because it means that they also risk being relocated somewhere where they don't know anyone, in a new prison, and further from their family. However, in overseas and in New Caledonia, in particular in the prison of Nouméa, which suffers severely from overpopulation, there have been an interesting situation because there is no option for transfer, which means that judges, magistrates have decided to free certain detainees, and of course with some safety measures to go with it.
Thank you. Another question from a participant called Leah. Do you have any estimation of the ethnicity of the pretrial detainee population? And secondly, how do you consider the prison population numbers, especially on pretrial, how it could be reduced? Are there other measures than those that you mentioned today?
Alors, vous savez qu'en France, les statistiques...
So, you know that in France, we don't have statistics or data regarding ethnicity, which means that I literally cannot answer these questions with any level of precision. However, I'd say that I can reply regards with foreign nationals, and foreign nationals are about 25% of the pretrial detention population. We have here a number of detainees coming from North African country, also from French-speaking sub-Saharan Africa, and also from a number of European countries, either from Eastern Europe or from other countries of the European Union. We also have amongst foreign nationals some people coming either from China or from Southeast Asia. In major urban centers, and that is similar to what we can find in a number of European countries, we have some groups who are more marginalized. Sometimes their lives are really difficult. Their social environment is underprivileged. Sometimes they come from a family background that is also underprivileged. There are some psychological problems. There are problems with their training. They have no access to work, and very often they deal drugs. And so this leads to an overrepresentation within this population of people who have an ethnic background but are French citizens. Amongst people in the pretrial detention, there's overrepresentation of foreign nationals. I said that this amounts to a quarter, but actually when I say 25%, probably this is an underestimation, and actually the real figure is closer to 33%. The reason is that foreign nationals have not necessarily a domicile in France, have a more difficult access to legal representation, and so therefore end up more easily being detained. Now, regarding the question as to how, or the means that will allow us to diminish the number of people in pretrial detention, well, I think that in the bills that have been voted, as I said in my presentation, since the year 2000, 10 such bills have been passed by Parliament who are strengthening the legal means that can avoid pre-trial detention. So all these bills have led to restrictions that prevent the judges to detain someone for pretrial detention. So judges now have to motivate the decision to send that person to prison, and it is only by default, only if there are no other means that such person can actually be detained. So I think that a lot can be done at the level of magistrates. I'm seeing this as an outsider because I am not a magistrate myself, that the strengthening of the means of the justice, so more judges and more means would allow the judges to actually speed up procedures. I think that is an important aspect, speed up procedures, and also, without generalizing, it is worth pointing out that the mindset of some magistrates is that when you are accused of an offense or a crime, then actually prison is the natural solution to a difficulty, and that they, in a way, ignore all the other options too easily. So it is not at the beginning of the investigation, it is not following the day where a crime has been committed that you can actually act and suggest another solution. But after 4 or 6 months, the judge will actually have to confirm whether someone should stay in prison. And there, the prison administration can actually act as an administration that will propose a solution, for example, the electronic bracelet.
Thank you. We will soon move on to our next speaker, but I will like to wrap up your presentation, Mr. Ridel, with a question from Cyprus. Our colleagues in Cyprus is asking, what is the percentage of foreign national citizens in French prisons? If you have statistics on this, and are they disadvantaged as regards to alternative measures to imprisonment?
Alors, c'est ce que je disais, nous avons 25%.
So, as I said, about 25% of people in pretrial detention, about the population in prison, are foreign nationals. That means that 75% of them are French, have French citizenship. As I said, there's an overrepresentation of North African countries, Morocco, Algeria, Tunisia. Also, populations from sub-Saharan Africa, such as Congo, Mali, Côte d'Ivoire, Ivory Coast, and others are also represented. And other foreign nationals come from European countries, as well as a few Asian detainees, such as from Sri Lanka or from India, Southeast Asia. The situation of foreigners in pretrial detention is the same as for foreign nationals. There is no discrimination here. All detainees have exactly the same rights in prison. However, judges will sometimes be tempted to suggest detention more easily when it is non-national than when it is actually a French citizen. because, for example, a non-national could actually be in France illegally, have no documentation. In that case, they will be sent to prison, and if the detainee is a foreigner, they may not be fully integrated in French society, they may not have had a job, their address also is questionable, and therefore it is considered that there are no guarantees that would justify for a measure such as electronic bracelet tagging. And so because these prerequisites are not being fulfilled, they will be sent to prison. And so unluckily for non-nationals, there's a higher chance of ending up in prison than if you are a French national.
Thank you, Mr. Ridel. I think this is a trend and a pattern that we can see in several European countries. Thank you very much for your presentation and your answers to these questions. For those questions in the Q&A that we haven't picked up on yet, we will try to do that later on in the webinar. I would now like to move on to the next presentation coming from Brussels and the European Commission.